SJC-11735, Commonwealth v. Travell, Stark.
Thank you, Fran.
Good morning.
Good morning. May it please the court, Alexei Tomasko for Mr. Starks. This case relies solely on one statute and one case, and there's a short version of the argument and a very, very short version of the argument that's 4 sentences long, so I'll start with that. Does the portion of Section 28A that permits review of sentences in excess of 5 years remain operative? Yes, and to quote Alfonso, the portion of Section 28A and for the review of sentences to the reformatory for women for terms of more than 5 years imposed by final judgments in such criminal cases remains operative. Notwithstanding the language that restricts that right to women, must it also be available for men under the First Amendment and the cognate provisions of the Declaration of Rights? Yes, and again to quote Alfonso, we cannot admit an interpretation that grants a right to women but denies the same right to men. Now to move on to the short version instead of the very short version.
What does operative mean in your sentence?
So this was where I would turn next to in terms of the statute. And certainly, I mean, to some extent, what did this court say when it stated operative? And I think we look at the two portions, the two clauses of the first sentence of Section 28A. And there's a right that is granted to men and a right that's granted to women. And I want to comment on the statute in a vacuum, and I know that's sort of hard to do, but without looking at Alfonso and without looking at the historical context, which I'll address in a moment. But if you're just reading the plain language of the statute, it grants two rights. And the right to men is a review of sentences to the state prison, which is really the nature of the sentence. It's a felony sentence. And the second thing it grants is a right to women for review of sentences for over 5 years. And I want to stress that it's over 5 years. It's not 5 years or more. So it is, for purposes of misdemeanors that I'm going to be talking about, it requires at least 3 consecutive sentences of at least 2 of which must be a maximum sentence. It is a very heavy sentence.
In the single justice's order, he says, your argument rests on the mistaken premise that if the sentences imposed on the defendant were imposed on a woman, she'd be entitled to a sentencing appeal under 28A.
Yes, Your Honor.
Is that your argument?
Yes. That is the first of 2 parts. That essentially any sentence in excess of 5 years under that statute, that portion still exists. That still grants a right of review for women that have that sentence. Now, obviously, it's encompassed if it's a felony sentence. If it's a 7-year felony sentence, that would be covered by the first portion once Alfonso is applied. For Alfonso, under the plain language of the statute, that wouldn't be the case, or that wouldn't be the case unless the second clause applies. Because the second clause says in excess of 5 years, that 7-year sentence would be covered by the second portion of the statute.
So you're basically saying that because your client got a House of Corrections sentence that was more than 5 years?
Yes, Your Honor. Well, so
that a woman would be able, under the second sentence, to have that appealed. And because a woman would be able to have it appealed, your client would too. And
yes, Your Honor.
And basically, Chief Justice Gantz is saying she wouldn't.
So the first part of the question is answered by looking at the statute and what happens under the statute, which is to say, if you have a 7-year sentence for a woman.
That's to the state prison.
No, that's not to the state prison. Just looking at the statute, or a generic 7-year sentence,
Okay.
regardless of whether it's the state
Okay.
prison. If we go through our analysis under 28A without looking at the extraneous interpretations, which we have to, but just for the moment, the 7-year sentence, under the first portion, she's not a man, and it's not to state prison, so it wouldn't apply. But the second sentence, it's a sentence in excess of 5 years, would apply. So under that second portion, she would be entitled to review. Now, the question, the second question is, what is our equal protection analysis?
But he disagrees with that, right?
He does disagree with that, and normally this.
And he's wrong.
Yes, this is yes, Your Honor. This is an error of law argument. It's the discretion or error of law. So we're under error of law as the argument, and that's right. And I can explain to the best. I mean, I feel I can explain where he's coming from, and I understand that. What Alfonso, and I accept that it's sort of a convoluted history in terms of who's appealing. Under Alfonso, a woman appealed under that first portion. And the question is whether or not that review was valid. And the court in Alfonso said it has to be. It has to be under equal protection rights, even though it nominally only applies to men. As I quoted before, we cannot admit an interpretation under the First Amendment that restricts that solely based on gender. Now, the court had an opportunity there to just toss the entire statute and say we can't recover this, but they said instead what we'll do is we'll apply it to men and women.
I mean, you don't disagree that there was a disparate sentencing structure in effect at the time that the statute was initially enacted?
I believe so. I accept, and the Commonwealth cites footnote 13, which says, in fact, there's it's comparable rights, and it didn't create a disparate appellate right. I think in this very bizarre circumstance that we're dealing with here, where we're essentially dealing with a number of consecutive House of Corrections sentences, we can get into this odd situation where women have this right that men wouldn't. To put it differently, for purposes of Alfonso and for purposes of disparate analysis, when we look at the history of 28A and the equitable opportunities that women had under the reformatory to just be released once they're reformed, whatever that means, that there would be equitable relief for women regardless of the length of the sentence by operation of the statute. Under 5 years, because it's the reformatory on its own can permit early release. Over 5 years, the statute grants that. So under that argument, essentially, women had rights equal to men. I believe it's disparate because what I'm suggesting is women had this additional right that men didn't, where if you string together at least three sentences, House of Correction sentences, at least 2 of which must be maximum terms, then you have the situation where a man can get a sentence in excess of 5 years, but not have any kind of appellate review under that first portion. So I'm not going to argue with the statement under footnote 13 that this court said, in fact, there's not a disparate appellate right. But what I'm suggesting in this case is we are dealing with that alternate situation where we do have a case that a man has a sentence, defined under Superior Court Rule 64 and the sentence that was imposed.
The alternative is to just basically say that the woman that you're positing that has this right does not have that right.
Well, and so that's what the single justice said is basically, and this is the second part of what did Alfonso really do? And one option is that they basically said, we're basically scrapping that second portion and just saying that everyone has review of felony sentences. And if that's the case, if that's what Alfonso said, Commonwealth is right, the single justice is also right. So, I mean, that would be the end of it. The other question is whether or not Alfonso made a distinction between these 2 portions and preserved the second. Basically said, this isn't in front of us today, so we're not going to address it. And certainly my argument, and I bow to the justices who were part of that court, is that it very, very explicitly went through this analysis of saying there are more than one portion, and as I directly quote, the second one remains operative. Not only did it directly quote that portion, the court sank a footnote that said, we want to quote the language we're talking about. We're not going to just say the second portion. We're going to directly address which portion we're talking about.
But your client received 2 consecutive sentences to the House of Correction for 2.5 years each, isn't that right?
He received a term of probation from and after the second sentence. And that is a very good question. Under Superior Court Rule 64, I assume that the follow-up question is, does a term of probation count for purposes of Section 28A when we're calculating length of sentence?
Well, my question was, if a woman had received consecutive sentences of 2.5 years to the House of Correction, she wouldn't have an appeal to the appellate division?
Without more, if there was only the 5 years, then yes, because you need more than 5 years. Mr. Starks also received a term of probation from and after. Now, this is the other, and I don't think the Commonwealth addresses this, but I'll make this argument for them and then say why I think it's not necessarily right. I don't want to presume. But the other question would be whether or not a term of probation counts for our calculation of length of sentence under Section 28A. Mm-hmm. And Superior Court Rule 64 says yes. I mean, that's the easy answer. The Superior Court has said yes. Terms of probation do count in terms of length of sentence. And I can imagine there's a couple different reasons, one of which is at the time of sentencing, a term of probation is almost always viewed as favorable. At the time of a violation of probation where a sentence is imposed, defendants tend to be kind of unhappy. And the court really wants to address these sentences all at once. If you have these consecutive sentences, probation from and after, you have a chance to object on day one. They don't want this piecemeal. I mean, God knows I've never heard of 2 consecutive terms of probation, but a court could do that if it wanted to. And the court, 2.5 years imposed, probation from and after for 2.5 years, probation from and after for 10 years. There's certainly within the discretion of a judge. I don't really know necessarily what would happen there. Although you are seeing that a little bit with a probation concurrent with a term of incarceration. But
Mr. Tomasco, yeah, could you wrap up, please?
But just to answer that question, the Superior Court has said that's the case, that it's going to review that based on these considerations of judicial economy. If this court were to reverse or overrule Rule 64, then yes, but in our case, because we definitely have 5 years, if this court considers that there's any possible term of incarceration related to that probation, we're over 5 years.
Thank you.
Absent any other questions, I'll rest on my brief. Thank you, Your Honor.
Good morning. May it please the court, Mary Lee for the Commonwealth. The Commonwealth is asking this court to affirm the order of the single justice because we maintain that's a correct reading of Alfonso and the statute. The first footnote in Alfonso notes that the sentencing changes in the statute that was enacted in 1993 and then became effective in 1994 actually repealed reformatory sentences. There are no more reformatory sentences. And moving on from that as well, in Alfonso, the footnotes also say that you either get, it's footnote 11, it says there are only 2 possible sentences in the Commonwealth, a state prison sentence and a House of Correction sentence. So the language that my brother is relying on is this sentence. It's at page 745 of Alfonso, and it says, while the portion of GL Chapter 278, Section 28A, pertaining to appeals by women remains operative, and it does footnote 14, the statute can no longer be interpreted as restricting the jurisdiction of the appellate division to only cases where a woman appeals from a state prison sentence that is for a term of more than 5 years. So So basically, the Commonwealth's position is that, the defendant's hanging his hat on this term about remaining operative, and I think what the Alfonso court was trying to say is, this is our main point. Women and men have equal access under Section 28A to the appellate division, not that women are getting more access than men have. And their opening clause of while this provision remains operative simply means that that clause has not been repealed, has not been found unconstitutional. It is still an active clause.
And what does it mean if it's an active clause?
Well,
I mean, because it might have been a better thing to just sort of say it's an archaic, it's superseded.
And they do actually say
that it's archaic.
It's a
they don't say it's
artifact.
Yeah, but they don't say it's superseded. Maybe that would have been the better.
I think what the court was trying to say is that the legislature hasn't repealed it and we haven't found it unconstitutional, but reformatory sentences don't exist, so it's never going to be applied again.
So operative means theoretically
Still on the books?
If we
books.
reinstitute reformatories,
Oh, okay, that's how it would be operative if reformatories were reinstituted.
if reformatories existed, it would then be used, but
Well,
they don't exist.
If there were a woman who had received a reformatory sentence in the days when those sentences could be imposed and then escaped and has not yet been returned, she would be returned to finish her reformatory sentence. So there may be somebody out there.
Having read the reformatory cases, I'm sure this court was as troubled as I was by the things that send a woman to a reformatory back then, so I would hope if that were the case, it would be null prost at that point, even though it's after the sentencing. The reformatory cases were quite troubling in terms of what happened to women who didn't conform to the mores of society as opposed to crimes being enacted. And that reformatory clause was meant to give women in those situations some relief. This is not the situation we are in now, where women, under Alfonso and under the 1993-1994 sentencing reform, women and men are then treated equally as required by the Constitution, and to put some more meaning onto reformatory without the existence of reformatories now would create a constitutional problem in the statute and would render that clause unconstitutional, I think. But we don't have to get there. The defendant received a house correction sentence, not a state prison sentence, and so he is not eligible under Section 278-28A. The defendant received a house of correction sentence, not a reformatory sentence, and so he is not eligible under Section 278-28A. In terms of how to view his sentences, whether you view them, as the 5 years that he received plus the 2.5, my brother makes a viable claim that Superior Court rule would view them as 7.5, but that is not how you view them under Section 28. The Commonwealth draws an inference from the Pelletier case from the appeals court, that's at page 22 of my brief, that sentences should be viewed singly, not in the aggregate. If the defendant is correct, it will create an anomaly within our sentencing structure, because a person in district court can receive consecutive sentences of 2.5 years in the House of Correction, and then all of those district court convictions would then be subject to a sentencing appeal before the Superior Court under Superior Court rules, and that can't be what the legislature was intending. And then my final note is that the defendant also did not comply with Superior Court Rule 64 that requires a person to personally sign their provisions, his attorney sign the provisions. So for any of those reasons, the appellate division was absolutely correct in refusing to hear the defendant's sentencing appeal, and I rely heavily on the well-reasoned opinion of the Chief Justice as acting as single justice in this case in his discussion of Alfonso. The holding of Alfonso is that this person who was sentenced to state prison had a right to appeal to the appellate division, and therefore there was jurisdiction for them to effectively raise her sentence. That's the holding of it. The dicta around that only says that men and women must be treated equally. It absolutely did not say women have more rights to get to the appellate division than men. That is not at all the import of Alfonso. So I would ask this court to affirm the decision of the single justice. If there are any more questions, I would be happy to answer them.
Thank you.
Thank you.